permission,
Yes, please.
may I mention, Millards, I know that it's a division bench matter, but Millards, I'm taking this liberty because of unique circumstances. Millards, this is an IA that we have filed for modification of an order passed by Justice C.R. Das and Justice Savitri Ratha in a tender matter. Millards, the matter was initially before Justice B.R. Sarangi's bench, but Justice Sarangi had recused. So, my lords, this would require a constitution of the bench. The urgent, my lords, is that Tuesday, my lords, the contempt in this matter is.
So we'll ask the DR to place it on Monday.
Grateful, lords, grateful.
Supplementary list for admission item number 1, ARVP 48 of 2020.
Lordships, I'm appearing for the petitioner. We are in receipt of a counter affidavit from the respondents, wherein they say that the due amount has been paid and the dispute has been settled and arbitration is not required. But however, not that's an incorrect fact, because they have very conveniently just paid the invoice amount and have not taken the interest accrued upon that, because the amount is pending since 2020 March, my lords. So the dispute
yes, my lord. My lord, this entire transaction related to NINL, my lord. Your lordship knows NINL is no more in existence. And your lordship will refer to order dated 7th of January 2022. And prior to that 20, your lordship first see the order dated 12th of 12th of November 2021, my lord. May I read that order?
Yes.
Mr. Mohanty Lanet, senior advocate, appearing for the opposite party, informs the court that 2/3 of the amount has already been paid, and if some time is granted, there may be no need for the appointment of arbitrator. This order was passed in presence of the learned counsel appearing for the petitioner. Thereafter, your lordship may kindly see the order dated 7th of January 2022. There, your lordship will see Mr. Mohanty Lanet, senior advocate, appearing for the opposite party, state that there is no dispute as such as regards the amount due to the petitioner, but only that it will take some more time to clear the dues. He points out that during the pendency of the present petition itself, over 11 crores has already been paid to the petitioner. He stated that hopefully the balance amount of rupees 6.95 crores will also be paid in the near future. It was also this statement was made in presence of the learned counsel for the petitioner. And on last occasion when the matter was listed, I was also appearing on behalf of the opposite party. Here also, I also said that in all probability the balance amount will be paid before the end of within 2 months. So, the last amount that was outstanding rupees 4 crore odd, that was paid on 28th of July 2022, as you lordship will find it from page 4 of the counter affidavit.
Yes, yes. And but what about this plea of interest? He said that interest amount is not yet been paid.
Because the amount that was raised by the petitioner was the principal amount of rupees 17 crores 99 lakhs.
That's an incorrect fact, my lords. I can show from the records that we have also claimed interest right from the beginning, from the day we have issued the demand notice, as well as till the time we have issued.
So what does the interest amount work out to?
My lords, as of date, the liability is to the tunes of 7.25 crores.
Interest.
Yes, interest along with principal, because the amount they've been paying, they've been adjusting towards the interest as well. So today the outstanding towards principal is 6.2 crores and some interest is 10 lakh something. So lords, it's somewhere around to the tune of, I am not just accounted for the damages which I am entitled for, lords. So therefore the dispute still persists, lords. So my honest request is that a tribunal may be appointed and the learned arbitrator may be look into
before my lord, once an arbitrator, my humble request is your lordship may kindly refer the matter to mediation, lord, because if both
so you can, if he's prepared for mediation, let's take one attempt at mediation.
Lords, I'll have to take instructions on that.
For mediation, you don't have, you try and sort out in mediation. If it doesn't work, the matter is anyway pending here. The next date will appoint the arbitrator.
All right, lords.
You say a counter affidavit has been filed on behalf of MMTC, stating that a total payment of rupees 1799,37,596, including a has already been made to the petitioner by MMTC, and that there is no outstanding amount to be paid to the petitioner. Paragraph. The counsel with the petitioner, on the other hand, states that the MMTC is not accounted for the interest due on the principal amount, and that according to the accounts of the petitioner, the payments that have been made from time to time by MMTC have been adjusted both against the principal and interest. Full stop. According to the petitioner, MMTC still owes it more than rupees 7 crores.
Yes, lords. And this is excluding the damages.
Excluding damages. and therefore it is prayed that the matter should still be referred to arbitration. Paragraph, counsel for the MMTC Limited suggests that the parties may explore the possibility of settlement of the balance dispute of the remaining dispute through mediation. The court is also the view that the party should first attempt at settling the disputes through mediation. Accordingly, the authorized representatives of the parties will appear before the mediation center of the High Court on 19th September.
Please do not.
19th September at 3:30 p.m. The report of mediation will be placed before the court by the next week. 30th September.
Deeply obliged.
For admission item number 2.
May please. My lord, I'm filing the rejoinder. I'm sorry, my lord, 80 years old, he could not, he was ill, so therefore I'm filing.
All right.
Just now I received the copy of the rejoinder, my lord. I will take instruction in this regard. Just
So
now I-
ultimately you have to go for mediation.
My lord, arbitration,
I mean arbitration.
yes.
Just now I received that.
It's all right. What is the total claim?
Total claim is 46 lakhs, my lord, as on 2020.
Anyway, so even with interest, it will come to less than a crore.
Uh, uh,
Even with interest, it will be less than a crore.
Yes, less than a crore.
You have a senior advocate appointed as an arbitrator.
My lord, may I suggest one name?
My lord, your lordship kindly have a glance to annexure page 21 of the petition, my lord. And he has not any claim as against the corporation, my lord. But they,
My lord, I'm filing a date, list of date.
agreement executed on 6/3/2013. And that agreement, the clause number 3 of the agreement states that the second is let out and the first party shall take on hire of the aforesaid go down for the period of 6/3/2013 to 31/7/2013. After the expiry of the agreement on 31/7/2013, Sri Pradeep Kumar Das, storekeeper, Cuttack Zone, had already handed over the go down to the petitioner on 31/7/2013 afternoon, which was communicated to you by the SP of Cuttack by his letter number dated 3/10/2013. After expiry of the contract period, no extension was sought nor any agreement executed for hiring of the go down. Your lordship kindly say, my counter his own.
So you're saying it is time bar. So you're saying it is time bar.
Yes, my lord. And a time bar also there is a point of limitation. Next one is, my lord, they have not eligible to get any claim.
That's on merits, sir. That's on merits. Explain limitations, sir.
Limitation, my lord, 20 they have rejected. 21 I have served notice. 22 I have filed. Your lordship may kindly see the
Last
last,
21 is the rejection.
yes, 20.
Anyway, even this can be examined by the
Arbitrator.
arbitrator. All right. Having heard learned counsel the parties, having perused the agreement in question and the pleadings in the present petitions, the court is of the view that the issues regarding limit as well as the merits of the claim of the petitioner can well be examined by the learned arbitrators in accordance with law. Paragraph. Accordingly, the court appoints, you were going to say.
Mr. SP Mishra, senior advocate.
Now, Mr. SP Mishra, senior advocate, to be the sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims, if any. The arbitration will take place under the aegis of the arbitration center of the High Court. All right.
Okay.
Item number 3.
Item number 3, your lordship, I'm appearing on behalf of Mr. Rath. Your lordship, we need some time to file the counter. We are in the process of drafting
Counter.
it. Yes, your lordship. I am appearing for NLU.
Counsel for the response seeks and is granted 4 weeks to file a reply.
Yes, your lordship.
Rejoinder for the next week. It's on 14th October.
Yes, your lordship.
Item number 4.
Oblige, Your Lordship. Not 14, sorry. 4 weeks will be 21st October. 21st.
Item number 4.
Your Lordship, in item number 4, I have obtained instruction from opposite party to appear in this case.
Right.
So Lordship, they are sending Vaklatnama in the meanwhile.
Correct. Counsel appearing for the respondent seeks and is granted 4 weeks to file reply to join him for the next day. Same
Madam,
14th October.
OP number 1 didn't appear. So if we record the press notice, or it can be sufficient also, because OP number 2 has entered appearance.
Right. You are for OP number 1.
Now, I am for the petitioner, my lord.
Right. So he is appearing for.
The noting is there, the tracking report is OP number 2, already they have entered appearance.
We are only for OP number 1. Is it? Both.
Patanjali.
No, he is appearing for both, sir. He is appearing for both.
Yes, then sufficient. Oblige, ma'am.
Yes,
Can I
sir.
short that, ma'am, can we?
No, 21st October.
Oblige, ma'am.
Oblige, Your Lordship.
Item number 5.
May I please, Lordship, my lord, I am VC, my lord.
Yes.
Present petitioner, my lord, is facing his trial, my lord. Initially being charged under section 395 IPC, along with section 9B of I Act, my lord.
I have some difficulty because the file has not been traced. I may permit to take a soft copy of the.
All right. You say counsel for the state says that his file is misplaced. He is permitted to obtain a soft copy of the file from the registry on a pen drive.
Diploma.
List on 14th October.
Yes, oblige.
All right.
Specialist. Specialist. Trial state matter, item number 1.
None appears. Dismissal non-prosecution interim order is vacated. A copy of the order be sent to the concerned trial court at the earliest.
Item number 2.
Same order.
Item number 3.
Same order.
Item number 4.
My lord, pass over. My lord. Item number 4, kindly pass over.
Pass over. All right.
Item number 5.
My lord, on the Cincinnati, I will take them next week. Mr. Cincinnati, the outhouse system, my lord.
So these are all very old matters, a 2004 matter.
Only 10 days take, my lord.
Now, what is the matter about? All right, at the request of counsel, the petitioner, list on 16th. Right.
Oblige.
Specialist item number 6 was confirming judgments are under challenge here. Confirming judgments, because the trial court has convicted, subsequently they have preferred the appeal against that order of the appellate court. They have come up in revision. All right from 2, 3.
None appears. Dismissal non-prosecution.
Item number 7.
When your lordship is not a trial stand matter, it is a conferring judgment of the conviction, your lordship. It is a conviction on 363, your lordship.
Yes.
It needs hearing, your lordship.
Yes, you can hear. You can hear now.
Lordship. Here, your lordship, it was in challenging the judgment of the traditional district and session judge, Master Court Baripada, your lordship,
Yes.
in which he has convicted the appellant under section. He has confirmed the judgment of the passed by the assistant session judge and convicted the appellant under section 363 of IPC and sentenced to undergo imprisonment for 2 years and the fine of ₹2,000, your lordship. Also, I will take to the lordship to the statement of the victim that is available. Your lordship, she was examined as PW 13, your lordship.
Yes.
I know the accused, the informant is my father. I had appeared in class 8.
Where is, which page is this?
Where do you copy, your lordship?
Deposition copies have been supplied because we have the in appeal the order has been confirmed.
Where is, which is, let's see, where is the deposition
LCR.
copy?
You also can pay to the LCR.
You soft copy the LCR. No, it's not hyperlink. You have to do this. Then how do you? So how do we proceed in the matter? All right, you said we'll have it 23rd September. List on 23rd September, the soft copy of the LCR be integrated. We made available on the next.
Item number 8.
None appears dismissal of office.
Item number 9.
None appears dismissal of office.
Specialist item number 10.
Yes, ma'am. But revision against conviction, both the petitioners were convicted under section 325-34 IPC and sentenced SI for 6 months, fine is 1,000 each. That was offered by the appellate court, but that was modified, the sentence that fine up to 1,000 each. And sentence was that is equivalent.
Then why do you want to challenge that?
Fine amount is concerned that is to be paid. Yes. 1,000 each by both the petitions.
All right. See, item 10, right?
Yes, sir.
The challenge in this revision petition is to an order dated 3/2006 of the learned Additional District Judge Noapada, disposing of criminal appeal 23 of 2003, whereby while upholding the conviction awarded by the learned SDJ Noapada by judgment dated 21st/10/2003 in GR case number 9 of 2002, convicting the petitioners under sections 325(8)(34) IPC. The sentence was modified to fine of ₹1,000 each only. Having heard learned counsel for the petitioners and having perused the impugned orders of the trial court as well as the appellate court, the court is not persuaded that any error has been committed by the first appellate court.
Plus, appellate court has converted the conviction from section
325 to
34 to 323. 34 of IPC.
And only fine up to 1,000.
Yeah, it's modified to 323, sir.
Yes. And only instead of imposing fine, only imposed fine up to 1,000 each.
Where do you get that? No, where do you get the first appellate court waiving the sentence and confining the only to the fine amount? Where do you get that?
May you pass it over, may I take it?
Just show him the paper.
Yes, yes. So for the operative person of the lower appellate court is in the result while affirming the order of conviction passed by the SDJ Noapada against the appellants in GR case so and so, I modify the order of conviction recorded by the SDJ Noapada under section 325(34) IPC to under section 323(34) IPC. But no punishment was no sentence was imposed.
So why have you challenged it? So Probation of Offenders Act has been released.
Yes.
You say the order of the first appellate court modifying the conviction to one under section 323(34) IPC. No, but not inclined. But without imposing any.
So he has the judgment passed by the London trial court. The London trial court has said So far as the conviction of 323 is concerned, hence each of the convicts is sentenced to undergo SI for 6 months and is to pay fine of rupees 1,000.
Yes.
In default, is to undergo SI for 3 months. So that he has got from this.
No, that is there here. SDGM. No. What about the first appellate court?
First of 323.
No, but without any sentence.
No, sentence. First of the
So what sentence do we presume then?
that at best that can presumed as rupees 1,000 because the trial court has said that so far section 323 is concerned, section 1 rupees 1,000 rupees fine is to be imposed. That is the reason why has converted only
Okay.
from section.
All right. As a result, the only sentence of fine of rupees 1,000 each on each of the appellants. Consequently, the court is not inclined to interfere with the indult order of the appellate court. The revision petition is accordingly dismissed.
Specialist item 11.
The interim order stands.
Okay, I don't want to mention Miller. Item 8 Miller. I am in difficulties Miller because I could not come due to rain Miller. May I pray Miller? This may be taken up. Miller, I'm Basudev Mishra, advocate. Item 8 Miller. Because
All right.
rain
We'll take it up on
23rd.
23rd. We'll take it up on 23rd. And item 8 is a request to cancel the petitioner.
Miller, may take it up
23rd.
next week Miller.
23rd, sir. 23rd September.
Specialist item 11. Item number 11.
None appears to dismissed in no opposition. The interim order is vacated.
Item number 12.
May I please? Well, here the petitioners, my lord, they have been convicted under section 323 and 34 of the Indian Penal Code by the learned trial court and sentenced to undergo SI for my lord, 3 months and to pay a fine of rupees 250 in default, SI for 15 days. That conviction and sentence were challenged before the learned lower appellate court, and the lower appellate court, while confirming the said conviction and sentence, only relied upon the evidence of the informant and not under any of the evidence so far as laid down by the independent witnesses, so the doctor. Because to frame a conviction under 323, as my lordship knows, my lord, the heart is the basic essential ingredient.
What is the medical evidence here?
Yes, the medical evidence is that, my lord, as per the evidence of PW 7, lordship will find the discussion at running page 17 of the brief. That is para 9 and 10 of the learned lower court's judgment.
Yes.
Page 17.
Yes.
Running page 17.
Yes, we have it.
First. Should I read, my lord?
Please.
So it reveals that nothing has been elicited from the mouth of PW2 to disbelieve her evidence. On the other hand, PW7, being the MO, medical officer, in his evidence deposed that on 12/6/2000, he examined Monglu Ghasi, and Monglu Ghasi is the informant injured. Monglu Ghasi, and found tenderness on the right thigh just over the knee. Similarly, he also deposed that on the same day he examined Sabitri Ghasi, another injured, and found 3 abrasions and 1 tenderness on the person of Sabitri Ghasi. And as per the cross, suggestion was given to them that they were traveling by bicycle, they fell down, and these injuries are there. A tenderness is only the injury.
So what? Still an injury, sir. Injury doesn't mean it has to be a cut, bleeding injury. Injury is injury.
No, there is no other material that the present petitioners have inflicted the injury.
Of course, PW2 is the witness.
Only PW2, my lord.
What is only? She is injured with her, she should be believed. Why should she be disbelieved? You see the.
And the independent witnesses, they have turned hostile during trial. That is,
Always that happens, sir. Always that happens.
PW3, 4 and 5. And here the conviction is, my lord, for 3 months.
You see.
For SI for 3 months.
All right.
And also lower appellate court has not taken care of the P Act. And also under 323, the maximum punishment is up to 1 year or with fine. That is there. Lordship may carry
SI is nothing at all.
Hello?
You only been awarded 3 months SI, sir.
Lordship may modify it to fine.
Why?
Because it is there in 323 that
you say
it will be maximum for 1 year or with fine or with both.
Yes, sir.
All right. You say the challenge in the present petition is to an order dated 6 July 2007 passed by the Additional Sessions Judge bracket FPC Jaipur, dismissing criminal appeal 103 of 2006, affirming the conviction of the petitioner under section 323. Petitioners under section 323 rated 34. I see. And also the sentence awarded to them by the trial court by the judgment dated 14 July 2006, namely 3 months SI with fine of rupees 250 and in default to undergo SI for 15 days. Paragraph. PW2 was the injured eyewitness, spoke of being inflicted lathi blows above the knee. Stop. However, the independent witnesses PWs 3, 4, and 5 turned hostile. Stop. The medical evidence of the doctor bracket PW7 a tenderness over the knee and abrasions. Stop. Considering the nature of the injury and the fact that the incident is more than
15 years,
15 years old. The ends of justice would be met by only modifying the sentence to fine of rupees 1,000 each and in default to undergo SI for 1 month. Full stop. The impugned order of sentence dated 14 July 2006 of the trial court and 6 July 2007 of the first appellate court shall stand modified accordingly. Revision petition is disposed.
Specialist item 13. Item
None
number 13.
None appears dismissal now.
Specialist item 14.
14, my lords, I am under the weather. I am appearing on these, my lords, if the lordship may permit me. My lords, I am appearing in item 14.
Yes.
Number. I have handed over a date chart.
Right. Yes.
The suit was filed in 17/9/2024. Thereafter, after passage of 3 years, your lordship may take note of this. After passage of 3 years, the written statement from counterclaim was filed and was taken on record. On 19/8/2009, the petitioner filed an application under order 22 Rule 4 of the CPC for substitution because the original defendant died, passed away. The last of the late Abhiram Mohanty was also filed petition for substitution, which was and the consolidated plaint was filed by the petitioners. Now, your lordship sees we had to file it on 23/7/2011.
The suit still pending. Is the suit still pending? Is the suit still pending? At what stage is it pending?
That I have not been able to obtain instruction because the matter has come up in the supplement.
You better find out, sir, if the suit is not there or not. Concept of the petitioner wants time to ascertain the current status of the suit, number 353 of 2004. In the
last page of the order, the last page of the impugned order, it says put up on 5/8/2011 for hearing of the suit.
So you find out what has happened. List on 30th September.
Interim order may be continued.
Yeah, interim order. What is the interim order?
The interim stay of the proceeding in the suit.
Oh,
It is ordered dated
suit has been stayed.
19th August 2011.
Oh,
Order
the suit has been stayed.
Yes, since my WS was to the counterclaim was my application was disallowed. Thereafter, I have come up before this.
Who's for the other side?
State.
Who's for the other side, sir? State.
State.
Private
It's called-
So why didn't you pay costs and be done with it? It's only a written statement to the counterclaim. All right. You say the limited challenge to the present petition. In the present petition is to an order dated 23rd July 2011. Passed by the learned Civil Judge Senior Division. In civil suit number 353 of 2004 declining extension of time oblique leave to file written statement to the counterclaim of the defendants under order 8 rule 9 CPC. Stop. No reasons have been given by the trial court to decline the prayer except stating that further time had not been granted on 2/5/2011 itself. Paragraph. Considering that this suit has remained stayed for 11 years now, court considers it appropriate to direct that, subject to the plaintiff petitioner being the respondent defendant, rupees 3,000 as costs within a period of 4 weeks from today. The written statement of the petitioner plaintiff to the counterclaim of the defendant shall be taken on record by the trial court. So the impugned order dated 23rd July 2011 stands set aside accordingly. And now the suit will proceed in accordance with law. Civil suit number 353 of 2004 will now be listed before the court of the Civil Judge Senior Division. Second additional, Cuttack on 10th October. Not 10th October, 17th October.
As your lordship, please.
17th October for directions. 2022 for directions. The revision petition is disposed of. Right. The writ petition is disposed of.
Specialist item 15.
Nana pays disposed not obstruction.
Specialist case admission item 16.
Madam, I'm in virtual mode, madam.
Yes.
Madam, in this case, the point raised here is that the writ petition, the committee report regarding caste has been challenged. And the it is pending, the writ is pending, the stay has been given. The criminal case is going on, the same committee report as an affair.
You can raise all the pleas, sir. You raise all the
Yes,
pleas.
my lord.
Permitting the petitioner to raise all the pleas urged in the present petition. Petition is disposed. Interim order submitted.
Item 17.
None appears disposed of no. Interim order vacated.
Item number 18.
Same order.
Specialist item 19.
Same order.
Item number 20.
Same order.
Item number 21.
20, my lord.
Yes, please.
May I please, your
Yes,
lordship?
yes. Carry on.
The present petitioner assailing the order of taking cognizance, that is page 15. Prior to coming to the order, my lord, your lordship may consider the FIR. FIR has been lodged at the behest of the government employee. Allegation against the fourth person, that is page 11. It has been alleged in the FIR that the mill owner, he had given some false checks, and that has been the allegation which has been depicted in the page 12 of the FIR, my lord. So far, the present petitioner is nowhere.
420, 468, 471.
My lord,
Ah.
that is true, my lord. Your Lordship may can see the page 12.
Yes.
FIR story towards last. The what cost namely, Sharat Chandra Pradhan, Jai Krishna Rana, so the mill, authorized by the miller to manage the watch, like lifting of paddy from the mandis. Maintenance of the meal record, submission of bill, delivered so and so. Proprietor of Messrs. Gayatri Rice Mill, Doctor has submitted to bank guarantee 20 lakhs each towards security. After inquiry, it has been found or as intimated by the bank manager. So allegation against the branch mill owner and everybody else who which has been appeared in the page 11 measure. So present picture is no one connected with the case. Neither mill is in the picture. Later on, what happened, my lord? The investigating officer, my lord, somewhere or other, they have implicated me in a without any relevant regime. This malicious proceeding has been initiated against the present petitioner. You will actually can see the page 12. Where is the allegation? Either I am involved in the Alice crime, my lord. Nothing else. No way connected with the case. Neither I am the mill owner. I have presented any check. That is the allegation which has been depicted in the FIR, my lord. So my humble before the achieve the taking of cognizance by the London court below, it is prime facie that non-application of judicial mind. Somehow or other, he has been entered in the instant case, then he has no right to claim the Alice crime. From the beginning of the it cannot find a basic case made out against the present petitioner under section 2468 for 71. Any offences is concerned. You actually can see the FIR story, which has been initiated on behalf of a government employee. The district manager OSCS Limited, Noapada. He is not else, my lord. He is a government employee. After doing inquiry, he came to know this is the allegation. What is the allegation against me, my lord? Page 12. Entire thing has been depicted in the FIR. No, where I am in the picture, my lord.
Sandeep Kumar Guru.
My lord. He is not named in the FIR, my lord. Neither any FIR has been registered against me.
But subsequently, his name might have come because after a substantial investigation, charge sheet has been filed.
Even though accepting for a moment,
after which cognizance has been taken.
So you can urge all the police, sir.
My lord,
I permit you to urge all the police.
my lord, why, my lord, I am saying so.
Clearly not being named in the FIR is not the end of the matter, sir.
Even the
investigation happens, charge sheet is filed, your name is
accepting for a moment, my lord. What is the allegation? What is the offense? 468.
So you are not able to tell us. The charge sheet, you not file the charge sheet.
Can I pray before the chief? Next week, I will file the charge sheet. Total charge sheet.
No, why? You must be having it with you. Show it to me now. We know what your role, what's the role ascribed to you.
I have to bring the certified copy for that.
That's all right.
Because your lordship knows
what is the allegation against you?
My lord, even by accepting for a moment, my lord, I am submitting before lordship. After enactment of the CRPC in 1973, first decision is India versus India. Thereafter, my lord, thereafter Bhajan Lal. What is the case, my lord, against me that I have committed any fraud?
So where is the charge sheet, sir? Unless without reading charge sheet, you can't simply say that.
Even
read the charge sheet and tell us what is written against you in the charge sheet.
Next week, any day, next week?
No. We're not adjourning. You have it with you, read it from there.
No, my lord, because I have not got that charge sheet for that.
No, it's okay. My counsel understands the court that a charge sheet has already been filed against the present petitioner. And it is on that basis that cognizance was taken by the order dated 16/10/2005. Paragraph. Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage. The petition is disposed of. The interim order is vacated.
Right. Can I pray before lordship? One thing, your lordship may kindly pass that order to that action. He has not been named in the FIR. Neither any role.
That's not here, neither here nor there. Yes.
Item 21, urgent copy.
None appears dismissed from office.
Item number 22.
None appears dismissed from office. The interim order is vacated. No.
Item 23, I'm not sure, no instruction.
No instruction dismissed from office. Right.
Item 23. Item 23. Item 24.
None appears dismissed from office.
May I take your there's some defective remove within one.
Tell us what the matter is about.
The matter is the application column question of coordination dated 7/10/2015 passed in the ST case number 59/2005 by the London below code where under section chart 376/417 reduced to 3 and SC.
Permitting you to take all the pleas, sir. Permitting the petition to take all the pleas urged in the present petition. The appropriate state petition. All right.
Specialist item 25. May it please the court, I am appearing on behalf of Subhashis Patnaik, the counsel for the petitioner. My lords, in this case, the facts of the case is that it was a dispute arising out of trade union. There was lost.
27.
25.
25.
Plus, the basic allegation is a 3-1 SCST, in which here the informant alleges that the petitioners called him as a dumb, or in ODI you can say that dumba.
It's all right, sir. All this can't be gone into this stage. So permitting the petitioner to urge all the pleas raised at the present petition at the appropriate stage.
Well, so only the thing is here, 3SCS is not made out because
All
it's
right,
not
you can urge all that in the trial courts.
right. Obliged. Item 26.
26 may I please? I mean virtual membership.
Yes,
Present person praying for quashing of the entire criminal against the present petition. The marriage was solemnized between the present petitioner and the informant, my lordship. For that reason, there is a compromise has been already made, my lordship. 3 SCST Act there, my lordship. FIR has been registered.
All right, so you can urge all the pleas, permitting the petitioner to urge all the pleas at the appropriate stage. The petition is disposed of into orders of later.
Obliged, my
Specialist for orders item 27.
None appears, this was not also.
Item 28.
My lord, it's a delay of about 26 days. It says come for further orders regarding stay.
No, what's the matter about?
This is an appeal against 1 hour passed by the learned tribunal.
What's the amount involved?
Amount involved is 47,000 rupees. Against one is OD claim, my lord. OD claim, he claimed for.
It's all right, sir. 47,000 and all don't. The amount being awarded being just 47,000 rupees. The court is not inclined to interfere with the impian award. The petition is dismissed. The appeal is dismissed, sir.
Specialist item 29 minutes so far. My first item is concerned. Amount is 59,850.
Yeah. Same order in Marka 1096 of 2005.
Millers, I have a cross appeal there. I have a appeal MSCA 665 for enhancement.
665.
Yes, but my enhancement is the person with whom I was working. He told that he is giving me 400. Was giving me 4,500. The London trial court held that he was only holding 1,800 rupees. A young man of 23 years died. The parents are the claimants, and if Lordship will kindly see the award, I would only say pray your Lordship to see the Constitution Bench judgment reported in 2017, 16 SCC. 16 SCC.
What's the date of the accident?
Miller's date of the accident is. I'm just 2002 Miller. 2002. July 2002.
All right. How old was he, the victim?
23 years.
So he was prepared to go before the Lokadalat, permanent Lokadalat.
Enhancement for enhancement.
Yeah. All right. This is an appeal for enhancement by the victim's family for enhancement of the compensation awarded for death of a 23-year-old son.
Yes, Mr.
Way back in 2002. The parties will appear before the permanent and continuous Lok Adalat of the High Court on 26th September at 3:30 p.m.
My point in this case, probably notice has not been served of New India notes, because I am appearing for New India, my learned friend is appearing for the Oriental, two insurance companies.
All right, both of you, on 29th September.
May be served up.
Yeah, 29th September. Copy of the appeal memo be served on both appearing for New India as well as Oriental Insurance.
Yes.
By within a week, I am serving.
If the proceedings do not end in a settlement acceptable to the parties, if the proceedings before the permanent continuous Lok Adalat, you say P and CA. T and CLA do not end in a settlement acceptable to all the parties. Matter will be listed before this court on 14th October.
Obliged. Obliged.
Item number 30.
I am for the respondent. You appear for me?
India respondent.
Respondent, all right. None appears to the applicant. This was the number.
Specialist item 31.
She already filed the claimant's appeal against the dismissal order of the tribunal, my lord. If a lordship please, it can be settled down in local.
What's the item now?
31.
She already filed.
Tell us what the matter.
Though there is a policy, insurance company believe and dismiss the claimant's claim, my lord, before the tribunal.
What's the impute order say?
And it can like grants to the phase 3 of the impugned judgment, my lord. The learned counsel for the opinion of 2 contended that exhibit 1 to 3 being the carbon copies of the affair, seizure list, medical requisition, those things have not been dismissed by the tribunal. Page 3.
Right.
The original in the middle portion of the para 8, my lord, at page 3, the original of which must have been custody either of the executant and some other persons. In that case, my claim has been dismissed, my lord.
No, unless it is forged. It's not a ground that it is forged. That is not a ground that it's been a forged or
my lord,
fabricated document. That your case.
I filed the documents, my lord.
No. Who's for the insurance company?
Here, insurance company is Oriental.
Anyone appearing for Oriental? Anyone appearing for Oriental? You appear. So you serve a complete set of the papers be served on counsel appearing for Oriental Insurance. The parties will appear before the permanent and continuous Lok Adalat on 30th September.
Specialist item 32.
This is
September at 3 p.m. If the proceedings do not enter into a mutually acceptable settlement, this before the court on 9th November.
This is also same matter.
Which one?
The next
32, same order.
And I'll shove the copy to the United India Insurance Finance. United India Insurance is the insurance here.
The difference is at United India. All right.
Item number 33.
So in this case,
Same date, all of
in this case, so far the filing of need copy is concerned, I can file it by next week. So far the statutory deposit is concerned, the court may grant me for 4 weeks time because I have to take instruction whether the appeal is alive, appellant is dead or alive, and as well as the respondent number 1.
Mr. H. Mishra, all right, Mr. H.S. Mishra, learned counsel for the appellant seeks 1 week's time to remove the defects pointed out. And his request list on 14th October.
No. Statutory deposit will take some time because after a long time the case is listed. As statutory deposit is to be made. There are 25,000 or something. So your lordship may grant me 4 weeks time.
That's what, sir. 14th October I've kept it.
Yes, sir. Fine, I'm sorry.
Specialist item 34.
Item 34, your lordship, no, I have no instructions.
No instructions.
In this, I'm appealing for the claimants.
Anyway, she says no instructions, not pressing the appeal.
Item number 5.
According to dismissed, it's not pressed.
Because my lord, I have filed a receipt today. And this is a case of injury where 30,000 has been awarded. My grievance is 9% interest. That should be
all right, sir.
Should be modified to 600. That's the prevailing interest pattern granted by all the courts. And I have deposited the entire award amount before this giving in favor of the claimant. No one is appearing for the claimant. That is the thing. But right from the beginning, nobody is appearing. Pardon me, my lord? Ajay Kumar Das is the claimant. Ajay Kumar Das is the owner. Oh. And who's the claimant? Claimant is, you've not made him a party. Yes, I made him respond number 2, Ronko Pradhan. Notice is not sufficient against him. I have taken notice on so many times. No, for respondent 1, there's one J. N. Pada. Respondent 2, no, that is Jagabandhu Sahu. Respondent 1, Ajay Kumar Das, is Jagabandhu J. N. Panda. Yes. Therefore, the owner, respondent 1. Cost was already. No, who's respondent 2 then? Claimant is respondent 2. Respondent 2 is Ronko Pradhan. Who's appearing for him? No one is appearing. I've taken notice on so many occasions, no one is appearing. No, despite service or? Pardon me, mail? Served. Okay. Despite service. The matter may be remitted back for disbursement, my lord. I have deposited the entire amount before this honorable court. All right. Considering that the petitioner has deposited the entire awarded amount before this court pursuant to the orders passed in the present petition, and further considering that none has been appearing for the respondent claimant, the court considers appropriate to direct the MACT 2, is it? That is MAC. Prestigious come MACT 1 Bolangir. MACT 1 Bolangir in the matter. As regards disbursal of the amount deposited in this court. But then this amount has to be made over to the concerned tribunal then. And the balance amount would be refunded to me with accrued interest.
Tribunals, they don't have their own account, my lords. It has to be issued in the name of the claimants.
Okay.
So now this money cannot be tribunal.
No. Do they have a means for disbursing amounts? No. The amount is deposited here. Can the tribunal direct the amount deposited here should be disbursed? No. Will be directed to deposit the amount before the learned tribunal and our satisfying before this. There is no account to the tribunal. They don't have any.
It has to be issued in the name of the respective claimant.
Respective claimant. Identify and disburse. The amount deposited in this has to the petitioner together with the interest accrued thereon. That very amount will be deposited. Refunded to the
insurance company, then the insurance company will deposit before that.
Yeah.
Or your lordship may direct, they will deposit the entire amount there, thereafter they will take back the check. That is the usual order passed.
All right. You say upon the petitioner showing the registry of this court, proof of having deposited the same amount in the tribunal. The amount deposited in this court will be refunded to the petitioner together with interest accrued thereon. The matter be placed before the MACT. What is it? Which is the MACT
1 Bolangir.
MACT 1 Bolangir. That is matter MAC number 145/2000. Be placed before the MACT 1 Bolangir for disbursal of the amount so deposited with it by the petitioner. On 27th October 2020.
Yeah, appearance will be looked at. I'm the respondent to the entire company.
All right.
I don't know, 36. Amount of appeal. And court fee I have already paid. Then the delay.
What's the delay, sir?
Delay of 90 days.
And amount involved?
The amount is even in the case of injury, only 7,000 has been awarded. It's a fracture injury of the claimant.
Fracture of what?
Fracture of right leg.
No, has it resulted in any disability or anything? No.
No.
Then there's nothing.
In our local minimum is 50,000.
Who's appearing for the respondent? There's no appearance also for the respondent.
No, insurance company notice has not been gone.
Then proceed. What is the point in now starting the whole matter?
If a lordship direct, I'll start.
You have not even paid the court fee for all these years.
I've already paid my lord.
When?
It's a wrong noting. Wrong noting, mate. Well, lordship coordinates me to start copy to the national insurance company.
7,000 for a fracture. What else? What is the
5,000 has been awarded only.
All right, it's a fracture anyway. At the end of the day, it's a fracture. See, ABC
117 is 1579 of 2009 for the reason stated therein, the delay is condoned. Counsel with the petitioner in the main MSC, appellant states that the court fee has already been paid, and so the noting is not correct. Paragraph. It is seen that for the injury of a fracture of a right leg, the petitioner has been awarded by the MACT Keonjar a sum of 7,000. Full stop. Considering that the injury has not resulted in any disability as far as the petitioner is concerned, the court is of the view that the impune award does not require interference. The appeal is accordingly dismissed.
Item 37.
Same.
Item number 38.
I filed a petition for exemption of court fee. It's a case of severe injury, only 12,000 has been awarded. The multiple fracture injury.
Since court fee you have not paid for 16 years now, sir.
No, I filed a petition for exemption of court fee, my lord. Court fee may be exempted. That's the provision in motor vehicle act, a court fee can be exempted.
How much have you been awarded for multiple fracture?
12,000, my lord. 12,000 has been awarded.
Multiple fracture of what all?
My lord.
And when did the accident take place?
My lord.
How many days?
Accident is
The delay is 301 days, sir. There is an inordinate delay of 301 days in filing the present appeal. The explanation is not satisfactory at all. The delay is not condoned. As a result, MAC 8 of 2006 stands.
Item 39.
39 also same, my lord.
Dismissed on ground of delay.
Item 40.
But the delay is 90 days, my lord. You may condemn the delay.
Three 45 days, sir. I don't know what you are noting is the noting of the registry is very different. Delay is 345 days and you're saying 90 days.
No, my lord, there are lots of cases I don't know.
So don't simply say 90 days then. The delay of 345 days is unexpected. Delay is not condoned. The appeal is dismissed.
Item 41.
Again, explain, see what the delay is.
How much delay, my lord?
Yeah, we'll see. 385 days. Dismissed. 42.
Item 42.
Let's see how much delay. 168. This one. What's the delay? All right. What's the amount involved?
Yeah. Of a case, I would have withdrawn. Limitation may not be condoned. The view of this one.
What is it? Death or injury?
Case of death. Tractor was
case of death 86,000.
In the year 92.
Whatever, sir. Whatever.
Said one thing. A tractor has certain passengers. Tractor is prohibited from carrying. Sir, no,
that liberty is always there.
No, unless
does
that
have
is
to be
given,
all this?
unless that is given, sometimes clients are not appreciating our petition.
It's all right.
File.
For 86,000, you'll be spending some lakhs of rupees to
Appreciate. Had I no point, legal point, I would have simply withdrawn this case.
All right.
Keeping in mind the
Right.
kindly give me that liberty so that I can recover it.
At this year,
We had
96 accident in 2022, to find something to recover. Sir, pointless, sir. Let's not multiply litigation.
87,000, now it will come to more than few lakhs.
Yes, yes.
With interest.
This is your original insurance, sir.
Here my liability is not there.
Right.
In view of section 2, division 34,
right.
A truck is meant not to carry any load.
Right.
But in fact, they were coming as passengers, 4-5 persons.
Right.
It captured one time. So that is why my liability is not there. Besides that, there is also no DL. What has observed, finding a see the finding. Even assuming they are coming as passengers, still the insurance is liable. Wherefrom we get this such sanction under law. This is erroneous observation, and also this finding is to be struck down.
All right.
Give me liberty here.
Item 44.
Usually, this honorable court appreciating the liability, that there is no liability so far as the company is concerned public money. Liberty is always good. I may try, I may not get the.
This is the delay. 44. 7 days. Who is in 44, sir? 44, Oriental Insurance. None appears. This is not question. Item 45.
Item 45 and 46, both is the demands appeal. During pending of the appeal, they have withdrawn the outright appeal.
All right. Both these appeals, you say matters become infructuous, disposed of as such.
Item number 47, 90,000.
90,000, since the amount involved is insignificant, the court is not inclined to interfere. All right.
Item 48.
Let's item 48. Well, let's an appeal on behalf of the state. Plus the amount is 32,000. The amount is 32,000.
Nothing at all, sir. And what is the delay?
That's 109 days.
Delay is not properly explained. Further, the amount involved is insignificant. Consequently, the appeal is dismissed. Right.
Item 49.
49, this is the claimant's appeal. Announcement of the awarded amounts. If the delay is only 10 days.
Delay is condoned. What is the amount awarded?
Awarded only 85,000 in case of death. Is the retired
audit. Matters referred to the permanent and continuous local adalat.
Since
attached to the High Court. To be listed there on 29 September.
Well, I'll serve a copy of the National Insurance Company in the meantime.
Copy of the petition be served on the National Insurance Company in the meantime. List on 11th November.
Specialist item 50.
In 43, statutory department may be referred. It has been dismissed. My appeal has been dismissed. Statutory made.
Why should it be refunded? Why should it be refunded? I don't know. Yes. Why should it be refunded, sir? Your appeal is dismissed. That's right. Your appeal is dismissed. Why should it be refunded?
Statutory deposit I have made.
Yes.
Because of the law.
Yes, yes.
But if you file an appeal,
yeah.
You have to make a deposit.
Yes. Why should it be refunded to you?
Or I'll deposit the less amount, less.
Whatever, so that's up to you. Yes.
Statutory deposit is not payable to him. Usually in all the cases, all the appeals, when it is disposed of, either dismissed or with some merit, then the statutory deposit will be, I'll pay the deposit the entire amount as on today, deposit.
What is the position?
This is the position.
On producing the receipt showing deposit of the entire awarded amount before the tribunal.
Then you add a standard line on the registry being shown proof of deposit of the entire awarded amount before the MACT concerned. The deposit made will be refunded to the appellant. All right.
Item number 50.
Let it come after 4 weeks because the appellate.
None appears to the appellant.
Whether I appear.
Yes, Mr. Mishra. Item 50.
50. Let it come after 4 weeks because the appellate in 2006 was 81 years. I will verify whether he is alive.
Sir, you're not audible.
But I have unmuted. Am I audible now?
Yes, yes.
The appellant in 2006 was 81 years old. Don't have any instruction. I have to verify whether he is dead or alive. And,
But statutory deposit also not made, sir.
but that is what 4 weeks time may be granted. I will do that. If he is alive and if he is willing, I will do
Okay.
it.
At the request of Mr. Mishra, list on 30th September. All right.
30th
Specialist item, September.
30th September, sir.
30th September.
30 September. Yes.
I think
Specialist item 51.
little more time, my lord. Your lordship may fix it. The other one is fixed to October. This may be fixed on the same date. Better.
All right. Which date in October is the other one?
The other one is, my lord, the
30th October.
October 22 or something.
21st October.
21st.
21st October. All right.
21st. Fine.
Item 51, 1,05,000.
All right. The amount involved is insignificant. Dismissed.
Item 52,
None appears dismissed on opposition.
item number 53,
Again,
3 minutes. This is the Cremant's appeal on the challenging the dismissal order. On the ground, we have not met the state as the party there. Regional Transport Authority vehicles met at the accident. The petitioners.
what's the law here, sir?
Law is against me, your lordship, 94 on the basis of the delay, your lordship may dismiss.
All right. There's an unexplained delay. Accordingly, the appeal is
There's a
dismissed.
case of injury, the minor injuries are there,
All right.
therefore I'm considering.
All right.
specialist item 54.
How much delay? Let's see. Let's see the delay.
Other side also appeared. And deficit court fee I have already paid, my lord.
250 days.
250 days not properly explained. The appeal is dismissed.
Item number 55,
None appears dismissed on opposition.
I am appealing for the respondent, man.
All right.
Thank you.
item number 56,
None appears dismissed on opposition.
item number 57,
And Lord, it's a Clement's appeal. Widow and 3 minor children are the.
What's the
appellant.
delay, sir?
Delay is 9 days.
1 minute, let's just check.
Judgment was on 22/11/2006. I filed the appeal on 20.
9 days delay is condoned. Which is the insurance company here or this is not insured?
My lord, I may be permitted to serve a copy on Mr. Datta, who usually appears. And the matter may be placed before the regular bench.
No, no, permanent local adalat, sir. Try.
My lord, the regular bench, it is kind of functioning every day, my lord. The competence is here. So
What difference does it make if you are agreeable? Itself. What difference does it make? Go before the permanent local adalat, settle it there, sir.
It will take time, already delay. It's a date case. And each and every account, it is a lesson. This was aged about 35, it was held 42. Apply multiplier in place of 15, 13. Determine the monthly income as a daily wage and less than the
So
daily.
why can't you go before the permanent local adalat?
My lord, because it is functioning every, it and my friend is appearing.
Yes, he's appearing there also. See, parties will appear before the permanent and continuous local adalat on 29th December. And list before the roster bench thereafter on 22nd November.
specialist item 58,
Same order, man.
Same order.
In 1958, my lord.
Mine
I am
has
for the
also-
respondent number.
He has already appeared, insurance
All right.
company.
All right. Same order.
specialist item 59,
I am for the appellant company, madam.
Yes.
Yes, madam. There is 4 days delay, my lord.
Delay.
Yes, 4 days.
What is the amount involved?
Madam?
Amount involved.
1,08,000, my lord.
Hardly anything, sir. Amount involved being insignificant.
20,000 we have already deposited, madam. 20,000 deposit.
The same line. If the proof of deposit of the entire amount is shown before the court, then the amount deposited will be released. Right.
And right of recovery, right of recovery may be granted, my lord.
Item?
Right of recovery may be granted, my lord.
Right of recovery. Right of recovery.
So that is, always there, so there's no need for
Valid driving license, my lord.
It's 2007 matter, sir. There's no now filing a suit for recovery.
Valid driving license.
Now you can't file a suit for recovery anyway. Yes.
Specialist item 60.
Claimant appeal, there is a delay.
Delay. Ah, 394 days delay, not properly explained. Next one also 61.
61. There is also delay.
One of the 331 days delay. All right. Yes.
Item 62.
62.
See the delay here.
Either misplaced loss.
4 days.
Delay 4 days condoned. What is this? Is a claimant's appeal?
I don't know, I have no.
We'll pass it over.
Item number 63.
Enhancement of the awarded amount. 40,000 is awarded.
40,000 for what? Death?
No, my lord. Injury to
What is the injury?
collarbone injury and also operated as affected as hydrocele, for which operation is going.
So who's the insurance company here?
I'm the insurance company.
So you go for the permanent look adalat. Parties will appear for the permanent look adalat. On the 22nd September. Then we put the roster bench on 16th November. Right.
Specialist item 64.
64. No, India. I am the claimant respondent, man. I am the claimant respondent.
Who's for New India? None appears for the appellant.
The peremptory order is there. Peremptory order is there. Statute default not filed till two.
Anyway, the second for non-prosecution.
Second one is the enhancement of it.
Yes. But the report beyond jurisdiction. Again, here you will have a problem, sir. New India, nobody's appearing. You serve it on him.
Is appearing.
Who's appearing?
Mr.
Serve him a copy. You say copy of the
Mr.
appeal demo be served on Mr. So and so counsel appearance for the New India Insurance Company.
Actually, Mr.
Be referred to the
Actual
permanent practice Lok Adalat on 22nd September and before the roster bench on 16th November.
I am for the respondent owner. Respondent number 2 owner.
All right.
Specialist item 65.
Then appears this was in Robert's question.
Specialist item 66.
Same order. 67, same order.
67.
Same order.
Item 68.
Then appears this is Roberts.
Item 69.
My pleasure, Lordship. Lord, here notice was issued to opposite party number 2. Opposite party number 2 is the mother of the girl to whom the petitioner number 1 has married. She is petitioner number 2 before your Lordship. Both of them have married, but a case under kidnapping was registered for which they have come for.
Is that affidavit of the girl, sir? Is there an affidavit of the girl?
Notice was issued to opposite party number 2 to the father of the girl. Oh, what is the endorsement? The Postal Department, I have not seen.
That's all right. So you urge all the pleas. You say permitting the petitioner to urge all the pleas at the appropriate stage in the trial court. the petition is disposed of.
Specialist item 70. Item 70, 498, husband and wife matter already compromised. Dispose of to dispose of the trial court within a stipulated period. Already compromise petition filed before the trial.
I see. Counsel, the petitioner states that the compromise petition has already been filed before the trial court. In that view of the matter, the petitioner is permitted to move the trial court for expeditious disposal of the matter. Pending there, the petition is disposed of.
Specialist
The
item
interim order is vacated.
71.
71 becoming
Infructuous disposed of. Interim order is vacated.
72.
None appears dismissed on opposition. Interim order is vacated.
Item 73.
None appears dismissed on opposition. Interim order is vacated.
74.
74, may I please, my lord, sir. Lords, the petitioner seeks the indulgence of this honorable court, thereby challenging the order at annexure 1 of the learned STGM as cut up, thereby taking cognizance of offence under section 18, 19, 20, and 21 of the TOHO Act, my lords, on the ground that on the self-same allegation, my lords, another FIR was earlier registered and the petitioners were on bail. And despite that being registered, a complaint case has been filed and the London magistrate has taken cognizance of the same. And it is hit by double jeopardy, my lords.
There's no jeopardy, sir. The second FIR is lodged. It's not conviction. You have not been convicted in the earlier case.
No, my lords.
So it's not jeopardy.
But for the same set of
that is a different thing, sir. That's TT Anthony. That's a different set of case law.
But the procedure under section 210 of the CRPC has not been taken care of, my lords, by the learned SCJM. As because
already you urged the pleas there, permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage. The petition is disposed of. Right.
Specialist item 75.
None appears. This was for non-prosecution.
Item 76.
Same order. 77 also same order.
77.
Same order.
Item 78.
Dismissed for non-prosecution.
Item 79.
Dismissed for non-prosecution.
For admission, item number 80.
Item 62, for claimant's appeal, look, I am serving copy the minor and
62.
62. 4 days delay or is condoned.
Delay is condoned. Same matters will be referred to the permanent continuous Lok Adalat. Parties will appear there on 22nd September.
My lord will appear.
And if no settlement is arrived at before the roster bench.
I don't have a copy of the
On 17 November.
copy of the appeal memo.
Copy of the appeal memo will be served on counsel appearing for the NIC. Given the dates.
May pardon on permanent before permanent local on 22nd September, and this matter will be listed for roster bench on 17th November.
May pardon that. Item 56. That the classical against newly award. Notice was issued, the owner has appeared, the insurance company yet to appear. Despite service of delay in this 56, my lord, but claimant's appeal against against the nil award actually.
What is the order passed in 56?
Non-prosecution.
You can't suddenly appear, sir. Let's finish the list and come back.
Okay, Ajilo. Thank you.
May I pardon, my lord?
1 minute, let us finish the list and then you can all mention. Yes.
Item 80.
None appears dismissed in opposition.
Item number 81.
82,000.
82,000. The amount is insignificant. Constant the court's not inclined to the appeal is dismissed.
Specialist item 82.
Appeal, my lord. That is the insurance policy, liability has been saddled against the owner.
How much is the amount, sir?
Amount is 1,35,000. my lord.
You deposited the entire amount or you
My lord, I have deposited the statutory amount before this court.
What is the statutory amount you deposited?
So 25,000 I have deposited.
Hardly anything, sir. What will the claimant do with that? Claimant has not been served. No notice is gone.
No.
It's a death.
It's a death case.
The amount involved is 1,35,000, with the accident having happened in 2002.
2001.
2001. The amount not being significant, but is not inclined to fear, the appeal is dismissed.
My lord, though there is a valid policy, insurance company is held liable to be compensated the
We're
amount.
not going into all that. See, that standard line, if the appellant produces proof of having deposited the entire amount, awarded amount before the tribunal concerned, the statutory deposit made in this court will be returned to the
Item 83.
ये लक्ष्य में both the parties have appeared. Local अदालत ये लक्ष्य में send it to permanent local अदालत, it can be.
What is the amount involved here?
Yes, I have misplaced the file today.
Let's see, we'll say see. No amount involved.
The last category one, if they are already. My guess is dismissed here, man. My claim is dismissed. Both the parties appear, all the parties appear, man.
Claim for death?
Yes, man. No, it's an injury.
Huh?
Yes.
We should be. So no injury report was filed, so only medical cash memos.
No, my lord. I filed all the GR case record before the tribunal.
No, but you have to prove all that, sir.
My lord, may kindly have a glance to the exhibits. A fair charge. Exhibits. The last page of the judgment.
There's no report. Without injury report, how do you expect to prove the case? You say this is an appeal directed against the dismissal of the petitioner's, appellant's claim by the MACT, first MACT Kyonger by the impugn order dated 10th November 2005. Full stop. This was a claim on account of injury. Full stop. The plea of the insurance company was that the driver had no valid license and the claimant was traveling as a passenger. However, no injury report was filed. Only some medical cash memos were filed. So this is certainly not proof of the claimant having suffered any injury. Therefore, the MAC justified in dismissing the claim. No merit in the present appeal, and it is dismissed as such.
Specialist item 84.
84 also misplaced the file, my lord.
Give it to him, give it.
This is also a case of injury, my lord. I have submitted a discharge report. What did not believe it, my lord. My lord, can I glance to the last two exhibits?
Xerox copy.
That time in police station, we collect the all Xerox copies of the GR case records.
See, the discharge certificate produced by the claimant did not show that any injury was suffered by the claimant in the accident in question. Consequently, the tribunal has not attended the claim, having heard learned counsel for the appellant. The court is not pursued to take view in the matter. With the injury not having been proved, the claim could not have been entertained. The appeal is accordingly dismissed.
My lord, I'm appearing for the respondent company. My name is.
All right.
Item 85. Amount involved is 99,940.
The amount involved is insignificant for a death. Consequently, if appeal is not entertained, it's dismissed.
Item number 86.
On behalf of the P.C. Patnaik, next week, my lord.
At the request of counsel for the appellant.
So my name is appearing, my lords. He was supposed to serve a copy on me, my lords. He has not served a copy.
A copy be served on counsel for the respondent.
I will inform it.
List on 16th.
It is 86.
Item 87.
May please, your lordship. However, the insurance company prepared this appeal. Notice has been issued.
Undelivered.
Yes, your lordship. I will please notice.
What is the amount involved?
Hello?
What is the amount involved?
Amount, lordship. 84,250.
The amount involving insignificant.
No, this is not accident. He is claiming for damage compensation, your lordship.
It's all right.
Vehicle has been damaged and he is paid for compensation.
It's all right. Yes.
Item 88.
Claimant appeal against Neil Awad, my lord. This is a claimant appeal.
So what? What's the reason for rejection, sir?
Rejection means OP number 1, notice has not been served. So he said dismiss against the OP number 1, for which entire claim application dismissed. OP number 1 dismissed against the OP number 1 case. So entire case is dismissed. Issue number 2 and 3 in my favor. But in issue number 9, as the OP1 dismissed, so entire case is dismissed for Neil Awad is passed.
So you did not steps to set aside that order, sir.
Mine.
In the absence of the owner, the claim is not maintainable. The claim has been rejected on the ground that earlier the case against OP number 1, who is the owner of the vehicle, was dismissed by an order dated 8 November 2000, and no steps were taken by the claimant to have that order set aside. As rightly pointed out, in the absence of the owner of the vehicle, who is the insured person, the case was not maintainable against the insurance company. The court is unable to find any error having been committed by the MSCT in coming to the above conclusion. The appeal is accordingly dismissed.
Item 89.
May please, your lordship. May I pardon, your lordship, item 87, the statutory deposit may be refunded.
Same order. Yes.
87.
Yes.
I beg pardon. I am. My lord, here in item number 89, I am for the petitioner, my lord. Last occasion, your lordship had heard this matter and my lord posted the matter because the advocate appearing for the opposite party did not appear that day, my lord. My lord, so it was adjourned. There is a case your lordship will find, my lord. My lord, a complaint case was filed.
Even today, nobody is appearing. Who's for the opposite party? State is only first party, right?
Please, my
Yes.
lords.
For the complainant,
The main contesting party is who?
the opposite party number 2 is the contesting party, my lord.
Darapu Palguna Rao.
And in the meantime, he has already expired, my lord. Falguna Rai has already expired, my lord. And there was a civil suit filed by the opposite party number 2 claiming partition in this suit property, my lord. That was dismissed, my lord. And in the appeal also brought by the opposite party number 2, which was also dismissed in the meantime. My lord, here what has happened, my lord, your lordship may kindly have a glance at annexure 1, the complaint petition, my lord. Complaint petition was filed, my lord, making out allegation that he has a my lord, share in the property, and the opposite party number 2 and the present petitioner number 2, I'm sorry, the present petitioner number 2 and the present petitioner number 6, they have sold a portion of the land, my lord.
So all these are complicated questions of fact, sir. And in the absence of the other side, we can't probably do this. You urge all the pleas at the appropriate states.
No, your lordship will find, my lord. Why I am challenging, my lord? Your lordship will kindly have a glance at page the annexure 2. On the basis of the complaint petition, the learned magistrate took up an inquiry and dismissed the complaint petition, stating that no offense is made out. Annexure 2 is the order, my lord.
So this petition was adjourned for you to find out the current status of opposite party number 2.
No, opposite party number 2 is dead in the meantime, my lord.
Sorry?
He is dead, my lord.
So then, how are you going to maintain this?
My lord, because your lordship will find, my lord, I am challenging the order of cognizance.
So nothing will, that whole complaint will go, sir. The criminal case will go now.
No, my lord, that is not the law. My lord, is that
there will be no witness. Go meaning what? It won't be able to be sustained.
Accused dies, my lord, then the case will abate.
No. If the complainant dies, there will be no. The prosecution will not be able to prove its case. That's
Yes,
what I mean.
but anybody wants, he can, my lord, prosecute the case.
Anyway, we'll permit you to urge all the pleas, sir. Permitting the petitioner to urge all the pleas at the appropriate stage.
Your lordship, why I am saying, my lord, your lordship may see the revisional order. In the revision application, your lordship may kindly come to page 23.
Yes.
My lord, here the learned court below sets the imputed order dismissing the complaint petition aside, my lord, and directed the learned court below the magistrate to take to reconsider the matter.
Correct.
Now your lordship may kindly turn to annexure 4.
Yes.
What the learned magistrate has done, my lord, he has not at all considered. He has only said, as per the direction laid in the said criminal revision number 4 of 2012, cognizance under section so and so has been taken. This could not have been passed, my lord. My humble submission before your lordship is, my lord, the learned revisional court remanded the matter for reconsideration of the my lord, order of dismissal, my lord. And he has not considered anything, and merely because the revisional court has passed the order, he has taken cognizance, which is not, my lord, sustainable in law, my lord. That is my point. My lord, how the learned magistrate can take cognizance solely because, my lord, it has been remanded back by the learned revisional court. He has not even, my lord, taken into consideration anything, the allegation, and he has not given a finding that prima facie case is made out. And without doing that, how he can, my lord, simply say that the revisional court has remanded the matter, therefore cognizance is taken. That is my challenge, my lord. Legally, it's not sustainable, my lord.
Yes.
Yes, that is my point.
All right. You can urge all these pleas at the appropriate stage.
My lord,
I'll pass a detailed order. I'll pass the order. Dismissed. Right.
Specialist item 90.
None appears dismissed in opposition.
Item number 91.
None appears dismissed in opposition.
Item number 92.
May I please, Your Lordship? Here I am for passing of the criminal proceeding. Petitioner is an associate professor of surgery, my lord, in a leading hospital in Bhubaneswar. Basically, the FIR relates to my lord, discharge of his professional activity of conducting an operation over a patient, my lord. And my lord, this FIR has been registered without following the Honorable Supreme Court guideline in that Jacob Matthews case. That when you register going to register a criminal complaint against a doctor, you have to first take an opinion of a medical board prior to launching the prosecution. Now that has admittedly not been conducted in this, my lord, complied with while launching this proceeding.
So it will go back then.
My lord,
You'll have to go back. It will have to go back for a.
now, in the meantime,
Go to examine it before.
in the meantime, it's a 2015 FIR. I believe in the meantime, the investigation must have been, what is the status of investigation? They can take instructions.
Constable, the state needs time to ascertain. But if the interim order is staying the FIR, then
No, my lord, only I have been protected. Well, I have only been
no
protected
course of
from arrest here.
No course.
I doubt very much any investigation took place. Anyway, Constable, the state wants time to ascertain the current status of investigation in the criminal case in question. That is request list on. November.
Interim order to continue.
Interim order to continue.
Oh, bless.
Item 93.
None appears dismissed in opposition.
Item number 94.
None appears dismissed in opposition.
In 95, 96, I am in BC Mallard. I am
Yes.
for opposite party RPF Mallard.
All right.
My name may be recorded.
All right.
Item 95 and 96.
Yes.
Same Mallard. Both the cases I am also.
95.
Ah.
Lords, I am on VC, my lords.
Yes.
A prosecution was drawn under section 14 AC of the Employees Provident Fund. The lordship may kindly see a demand notice was made, which is at page 19, annexure 3. But the entire amount with interest has been paid at page 25, annexure 5, my lords. So the prosecution cannot continue as the entire amount with interest has been paid, and that is my stand which I have already taken. Your lordship may kindly see at paragraph 10. In paragraph 10, I have already taken a stand that entire amount with interest at the rate of 17% has been paid. In the meantime, my lords, this Mahalakshmi cinema, that is petitioner number 1, no longer exists, and petitioner number 2 is already dead on 9/8/2020. Petitioner number 3, I don't know, he was 73 years old. I could not contact him as on 2015. So whether he's alive or not, I don't know. So, and at the same time, the prosecution cannot stand because the entire section 14 has been complied with.
Yes, what do you say, Mr. Monty?
The copy may be solved, I'll take instruction. Even if the amount has paid, but the differential period, the amount, the interest has to be charged. What date is your amount was calculated, what they paid, the copy may be solved so that I can assist your lordship.
So in fact, nothing, because petition number 2 is no more there. Petition number no more exists. So against whom will he proceed?
Mr. Mukherjee, either you withdraw the petition then, or if you want to persist with it, you will have to serve a copy on him.
I have, because I don't know about petition number 3, I have to take instruction whether he's alive or not. In the meantime, I can serve a copy.
All right. Copies of the petition be served on Mr. Monty, who appears for the respondent, to enable him to take instructions on whether the amount involved has already been paid. List on. November.
95 and 96.
Same.
Yes, 94 to 96, all same.
Put down all three numbers together.
My
Item
name will be recorded
97.
in the cases.
Item 97.
Obliged one.
My jewelers.
Yes.
and petitioner challenging the passing of proceeding, and I have annexed the FIR, my lord. Her allegation is that while the my lord were performing my lord patrolling duty, got information regarding some explosive on the my lord house of one my lord, house of the accused person, namely Hemant Kumar Patra, my lord. I have not named in the FIR, my lord. Thereafter, they searched the house and found some my lord, explosive substance. A seizure list was prepared.
You can urge all these pleas, permitting the petitioner to urge all the pleas raised.
And here in this case, my lord, I am a licensee, my lord. I am a shop my lord, where and I have no my lord, way connected with the case, my lord. All right. And without taking any investigation properly, my lord, charge sheet has been filed, my lord. And my lord, in case of substances which has been my lord given a seizure list, that is also not on the purview of Explosive Substance Act, my lord. I have annexed, my lord, the bills as well as the my lord page 27. I have a inquiry was also, a letter was sent to the my lord Government of India, Ministry of Commerce and Industry, page my lord 26 and 27, where it has been written that these materials were which has been seized is also not explosive, my lord. And I am a licensee, my license is valid.
Anyway, you can urge all these pleas at the appropriate, permitting the petitioner to urge all the pleas at the appropriate in the trial court. The petition is disposed of. The interim order is vacated.
Item 98.
I may please also. There are 5 petitions are here. Out of the petition number 1 is expired in the meantime. And this is regarding passing of Annexure 1, the FIR laws dated 9/1/2015. But this is filed only to counterblast to the Annexure to the my FIR. The wife of the petition number 4, my lord, has lost the FIR due to a family dispute. And the petition number 2 is a doctor. He was no more in existence and present at the in any manner, my lord. And it's order dated 17/3/2015. Lordship perhaps granted some interim protection, but thereafter I have no into about further.
Permitting the petitioner to urge all the pleas raised to present at the appropriate stage, the petition is disposed. All right.
Specialist item 99.
99, may I please your lordship. Here the present petitioner, the present case is arising out of a matrimonial dispute, and the present petitioner is the accused. OP number 2 is the informant, OP number 3 is the wife. They have filed the affidavit of compromise affidavit at flags B and C, my lord.
You appear for them?
Yes.
All right.
My lord.
The opposite parties 2 and 3 have filed their affidavits, confirming that there's been a compromise between the parties, and that view of the matter take from the prayer clause, and all proceedings consequent thereto are hereby quashed. Grateful.
Specialist item number 100.
Made Lordship members. The petitioner seeks to challenge the order of cognizance in a complaint case on dated 1/10/2013 annexed to 2 milers, page 24 milers.
Yes.
Cognizance taken on allegation of violation of offense under section 21 of Mines Minerals Development Regulation Act 1957 milers. But first and foremost, milers in additional affidavit taken on ground is barred by limitation milers.
That's okay. All these pleas can be urged at the trial court. Permitting the petitioner to urge all the pleas raised in the present petition in the trial court at the appropriate stage. The petition is disposed of, interim order is vacated.
Including limitation milers.
Yes, yes.
Item 101.
May I please judge? This case, my lord, the Lordent court below have taken cognizance on under section 630 of Companies Act, my lord. By the time the complaint case is filed before the SGM Jharsuguda, my lord, by the time the act itself has already been repealed, and 2013 Act came into force, my lord. And the complaint filed under old section, my lord. Accordingly, the 2014, my lord, it came into force, my lord, 12/9/2013, my lord. By the time that act was not there, but the London SGM took cognizance under section 630, which that act not in survive, my lord. Subsequently, the counsel for the complaint filed a petition 2015 to alter the cognizance, my lord, offense, my lord. Accordingly, that has been altered on 16/4/2015. My contention before Lordship, my lord, when the act not survive, my lord, the SGM is not competent to take cognizance against the petition under section 630 of Companies Act, my lord.
Anyway, so you can.
My lord, I am appearing opposite party.
All right.
I guess, my lord.
1 minute, permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage. The petition is disposed of into modus vacated. Yes.
My name may be recorded, your lordship.
All
I am
right.
appearing for the full.
Item 102.
My lord, in this case, I have already filed an affidavit, my lord. Your lordship, kindly call this matter along with that affidavit, my lord.
What affidavit?
My lord, my senior has last time told me to file some documents. I have filed one affidavit along with that document, my lord, about disciplinary. My lord, that affidavit also call this matter along with that affidavit so that my senior will place this matter, my lord.
No, disciplinary proceedings over or not?
Yes, my lord. This,
My,
I have
lord,
that.
my lordship, kindly take a look.
Proceeding is over
Uh-huh.
and no, the charges were dropped.
Dropped.
Yes.
All right. Counsel for the state confirms that in the disciplinary proceedings, the charges were dropped and the petitioner stood exonerated. In that view of the matter, GR case number so and so taken to clause and all proceedings consequent to stand hereby. All right.
Specialist item 103.
May I please, Lordship, the
Yes.
order challenging the taking cognizance, Lordship. The offense under section 109 of the petition, the present petition is the wife of the public servant. The status of the case, I could not maybe taken up next week any
All
day.
right. Counsel, the petitioner needs to ascertain the present status of the matter in the trial court.
Lordship.
I heard request list on. October.
Yes. Oblige.
Specialist item 104. Item 104.
None appears to is not prosecution.
Item 105.
May I please proceed? Petitioner is working as a inspector of police, my lord. During the election month, there is a patrolling duties he is performing, my lord. And she has seized a cash of rupees 12,000 from the opposite party number 2, my lord.
Yes.
And in this regard, he has filed a FIR on annexure 1, my lord, which is registered as under offense 392, my lord, against the present petitioner, my lord. After that, my lord, on annexure 4 at page 15, it is in Odia, my lord. The complainant has also received the amount from the petitioner.
So unless there's an affidavit of the complainant, we can't proceed.
The notice was issued.
That's all right. If you're not participating, then you have to go for the trial court only, sir.
My lord, notice was issued, but it was wrongly received by.
I don't know, sir. See, without the other side being here, I can't possibly record the fact that
yes, the amount. It was wrongly sent to received by one other Gangadhar Raut.
Whatever, sir.
My lord, the notice was served.
Anyways, permitting the petitioner to raise all the pleas urged in the present.
And another thing, my lord, there is no sanction order.
That's all. All that we can raise this. The petition is disposed of. All right.
Pastor man. Specialist pastor item number 4. Item 4.
May I please, Your Lordship?
Yes.
I'm submitting a lot of submission. This is a criminal revision wherein we have assailed the judgment of conviction and order of sentence passed by the trial court, which has been confirmed in part by the additional sessions judge. Your Lordship.
Yes.
The petitioner stood convicted in respect of offences under section 409, 468 and 420 of IPC by the trial court. On the appeal, he has been acquitted and the charges under section 468. He has been acquitted under the charges under 468 and 428 by the appellate court. So now,
what is the remaining conviction?
It's 409, Your Lordship.
409.
Only 409, Your Lordship. For which he has been sentenced to undergo an array of 1 year and a fine of 1,000 rupees. and subject to default of payment of the fine to further undergo a RIP of 1 month. Lordship, the case of the prosecution on that has been lodged on the basis of an FIR is that in the absence of the petitioner that he was working as the sub postmaster and he used to receive deposits in saving bank account and recurring deposits by putting his initials in the receipt passbooks. It is alleged that the petitioner received deposit from one Aditya Devri and 7 others named in the FIR and has put official seal and his signature in the passbook. It is alleged that the petitioner has misappropriated a total amount of rupees 9,950, which came to light only when inspection of the post office by the subdivisional post inspector was done as per the direction of the superintendent of post offices. To substantiate the charge of the prosecution, has examined 13 witnesses, including the subdivisional inspector postal, who is Sanatan Muduli, the informant, but your lordship may mark that he is not the subdivisional inspector postal who has detected the misappropriation as per the direction of the superintendent of post offices, your lordship. And 3 investigating officers, PW 7, 12 and 13, PW 2 to 10 and 11 are the account concerned post offices. The remaining witnesses are the Caesar witnesses and other official witnesses. And there are no witnesses that has been examined from the side of the defense. Being convicted by the trial court in respect of offense under section 409, 468 and 420, the petitioner preferred the appeal. The learned appellate court was pleased to hold as follow in paragraph 9 of the judgment, your lordship. I may be allowed to place that para. With regards to the
Mr. Katkesh, she says a POA Act can apply here, can it?
Yes, yes, it can be applied. So loss we can reduce it to fine.
We pass the order, reducing it to fine.
Yes, sir.
Right.
Obliged.
Item 56. Enhanced appeal against the new labor, my lord. Notice was issued, the insurance company appear.
Which is the insurance company?
But New India Insurance Company. On Subhavikas Panda has appeared.
56.
56.
We'll have to serve another copy on the present counsel for.
As well also.
This is United India.
New India Insurance.
New India. Okay. A copy be served on New India Assurance Companies Council, Standing Council. Parties appear before the permanent and continuous local Adalat on 30th September. Then before the roster bench on 19th November.
Item 72.
All right. Council seeks leave to withdraw, dismisses withdraw.
Over.
1 o'clock.
Item number 1. My lord, I pray 2 weeks time to file. Once I have also taken, while your lordship granted stay of operation of the judgment, on that day your lordship allowed me time to file counter. For the first time I am saying 4 weeks time may be allowed to file counter.
All right. Reply
And
be
for
filed-
private respondents.
reply be filed within 4 weeks, adjourned for the next date. 11th November. Interim order to continue.
11th.
That's.
Orders item number 1.
Mr. Salve is leading me in this.
Yes, yes.
I'm sorry, Malad, I didn't realize. Malad, we had, sorry, we are back as back pennies, but we had
Yes,
given an
yes.
undertaking to pay on the very first price. And they obviously made a mistake, because if your lordship just sees my application,
Yes.
there were no transactions in April. One party filed a return, which he has corrected. But on the basis of that return, they notified 1461. They corrected it in May. The May price they've notified for the state of Orissa itself is 436.
Yes.
And for the neighboring states, Andhra, Karnataka, Madhya Pradesh, it's 700, 600, 700. This 1400 is obviously a mistake. I was suggesting, my lord, the IBM is appearing before your lordships. Can they have a
Yes.
look at it and come back to my lords in a week's time? Because if we have to pay it 1460 as against 5, 6, 700, it's a huge, huge, huge difference. And we have to pay for 2 years at this price.
All right.
If you let them have a look and come back to your lordship, because that person has also corrected his return. I've said that.
Mr. Padi?
Yes.
You'll have to unmute, Mr. Padi. Mr. Padi, yes.
Yes. My lord, I sought for instruction. I do have. Let's give some time in the who have already notified earlier.
Right.
It was already been uploaded in the system website, my lord. With regard to my lord, senior has submitted about the annexure 18 and all these things. I have to take instruction, my lord.
All right. All right.
My lord, may I say something?
Yes.
Would your lordship look at the last order, order number 7, 20th of May, 2020.
Yes.
No, actually, they have not been paying because they undertook that within, may see para 6 minutes.
Yes.
Petitioner undertakes before this honorable court that within 30 days of the ASP of iron ore so and so, notified by IBM, petitioner shall deposit premium royalty annuity in advance to meet its obligations. So now, my lords, on 28th, this has been now notified on the 28th, on 28th of June, it has been notified as 1461. What they were earlier paying was at the rate of 12687 and 1337. Lordship, that 4 weeks has expired. The matter was listed thereafter. They undertook to pay. They have not paid anything.
May I suggest something, Maran?
Yes, yes.
There is an all India notified price. I will pro tem deposit on the all India notified price. My learned friend's point is correct. We should have paid at least something. I'll pay the all India notified price within 2 weeks. Let the IBM come back to your lordship.
All right, all right.
If it doesn't work, then we'll pay the balance.
All right. The present application by the petitioner seeks clarification regarding the declared ASP for iron ore fines below 51% in the state of Orissa for April 2022 by the Indian Bureau of Mines bracket IBM. It is stated that despite the representations of the petitioner with the IBM asking it to revisit the declared ASP, there has been no response. You say notice, they accept notice. Mr. Salve, learned senior counsel to the petitioner, states that the petitioner will pay the all India notified ASP for the month of April 2022 within a period of 2 weeks from today, without prejudice to the rights and conditions of the parties. And this will be subject to the further orders passed by this court in the present application. Before the next date, Mr. Paddy, learned ASGI, states that before the next day, he will obtain instructions from the IBM on the ASP published for the month of April 2022.
Not we only had minus 51. Will not we only had minus 51 because April price for all India for minus 51 grade, so that there is no dispute.
Which is below 51 FE grade.
For iron ore fines.
It's okay, my lord, the instruction as a whole. It is better.
All right.
Not it.
List on, should we have it on 28th October?
Village man, yes.
28th October. Right. All right.
Grateful man.
Lordship, please.
Right.
Supplementary list for orders, item number 1.
May I please your lordships? My lord, this is an IA for modification. Your lordships order dated 23 March 2022.
Yes.
If your lordships may see the order dated 23 March 2022.
Right.
Your lordships had directed the petitioner to file a revision petition before the RDC.
Correct.
But my lord, the petitioner, my lord, as per your order, it has to be filed
not later than 2nd May.
2nd May.
So you could not file it by that date.
My lord, the petitioner was ill.
All right. You want to extend the time?
Yes, my lord.
When have you filed it, or you not yet filed it?
No, my lord, I haven't filed it.
Extend the time.
Yes, or I don't have a copy of the IE, but in any case, my lord, let them mix. I don't have a copy.
My lord, I'm supplying a copy upon my.
Yeah. You say the time, the order dated 23rd March 2020, the application has been perused and the parties have been heard. The order dated 23rd March 2022 is modified by extending the time for the petitioner to file the revision petition in terms of the said order. till highly operational, 3rd October 2022. Right. The application is disposed of.
Orders item number 2.
Your Lordship, in order dated 1/8/2022, while passing the order, there has been a typographical error that
Yes.
instead of BL/4, it has been mentioned DL/4 in the paragraph 2 of the order.
Paragraph 2.
Paragraph 2, yes, yes.
All
yes.
right. The plot number is corrected as prayed for in paragraph 2 of the order dated after judgment dated 1st August 2022. All right. That's the only one.
Urgent certified copy may be.
All right. Urgent certified copy be issued. All right.
Thank you. Thank you.
Namaskar.
Namaskar.